Hi, this is Scott Pierce. This seminar covers constitutional law, and I think you're going to discover that this approach to constitutional law may prove to be a lifesaver on the bar examination. This approach is less a laundry list of issues and more a systematic way to think about constitutional law. We're going to discover that, more often than not, issue spotting on con law essays is pretty straightforward. Very often the examiners will just tell us in so many words exactly what issues are at stake. But sometimes they don't. And when the examiners don't tell us what the issues are, we've got to be able to figure it out for ourselves. And constitutional law can be especially difficult with regard to issue spotting. And that means it's very important for us to have a systematic approach to constitutional law that's going to allow us to fly by instruments through the fog of a difficult question and spot the issues, resolving them appropriately. And if you are a person who hasn't been educated in America and now are getting ready to take an American bar examination, constitutional law literally is foreign territory. So again, it's very important to understand the basics of constitutional law and a fair number of the fine points too. I think you'll discover that constitutional law is probably the easiest subject on the multi-state. They really have problems coming up with tremendously clever con law MBE questions. While they make up for it on the essays, con law essay questions, at least in my way of thinking, tend to be somewhat more difficult than their corresponding counterparts on the multi-state. I guess all of you are going to find out for yourself one way or another. So now let's consider specifically how to approach con law fact patterns. You'll notice that the first step in our con law approach is the same as our first step in torts, and I think that familiarity ought to be helpful. The first thing we want to do is identify the plaintiff's injury. And here, unlike torts, the plaintiff isn't going to be complaining about being injured in a car accident or scalded or otherwise physically abused by the defendant. Here, the injury is likely to be somewhat less tangible. So somebody's going to be denied a job. An organization will be denied a permit to march. Or, as we'll see early on in our work together in this seminar, an association feels that some statute has wronged the members of the association. So the first thing that we do is identify the plaintiff's injury. And again, we want to be as specific and as comprehensive as we can. Next, we identify and focus our attention on the plaintiff. If the plaintiff is a private party, then we've got to establish that the plaintiff has standing to pursue constitutional theories of liability, and we also have to consider ripeness and mootness. And these threshold issues need to be discussed in the context of the facts. Here, as much as in any other subject, we want to stay away from boilerplate recitation of law. We want to focus on connecting the facts from the pattern with elements of the legal analysis. So, if the plaintiff is a private party, we consider standing, ripeness, and mootness. If the plaintiff is a government, we consider intergovernmental immunities. Okay, that wraps up considering the plaintiff. We consider the plaintiff's injury, and then we think about and consider who the plaintiff is and the issues that typically are triggered by the identity of the plaintiff. Next, we focus our attention on the defendant. If the defendant is a private party, we've got to consider state action. If the defendant is a state or local government, we need to consider interstate privileges and immunities, the Commerce Clause, perhaps the most heavily tested issue in con law outside of individual rights, express or implied preemption, and police power. And as you will notice as you go through the model answers that I've written for constitutional law, I find the police power to be almost omnipresent when we have a state asserting the right to do something. So you will read many allusions to the police power in my model answers. Now, if the defendant is the federal government, we need to consider the powers that the different branches of the federal government have. First, we begin with the executive powers, both domestic and foreign. Next, we turn to the judicial powers, And here there isn't a great deal that they can test us on. They can focus on the federal system, the Article III courts, or they can direct our attention to the Article I courts, including the bankruptcy courts. The most common branch of government that we face exam questions on in con law essays is Congress. And here, the most commonly tested issues include the Interstate Commerce Clause and the Postal Authority. Obviously, interstate commerce is really the big one there. Taxing and spending power, foreign affairs and aliens, the necessary and proper power, and the enabling powers. That wraps up what they can test us under legislative powers. Mostly what we're dealing with here is taxing, spending, and interstate commerce. When we think of constitutional law, and when I find myself speaking to foreign attorneys about constitutional law, the different branches of government and their different authorities and federalism issues, the relationship between the states and the federal government, come up quite often in those discussions. But the area that we all agree is the core of constitutional law is the set of individual freedoms that are guaranteed by the Bill of Rights. And here there are a series of rights that commonly are being trampled on, at least allegedly, by defendants in con law litigation on bar exam essay questions. You can see in the approach that I break these down into very predictable categories. First, we begin with the First Amendment, and that includes the First Amendment freedom of expression and First Amendment freedom of religion. Under expression, you know that includes freedom of speech, including reasonable restrictions on time, place, and manner, freedom of association, and freedom of the press. We'll see interesting issues from all of these areas in our work together on this subject. The other First Amendment issue, freedom of religion, also extensively tested, and here we consider the Establishment Clause and the Free Exercise Clause. These issues are always tested on the multi-state. They are less frequently tested on the essays, but they show up often enough that it's well worth our time to be prepared for them. Next, we consider the Due Process and Equal Protection Clauses. These issues are omnipresent on bar exam con law essay questions all across the country, and in particular on California, they show up with great regularity. With regard to due process, please realize that the Fifth Amendment binds the federal government, the 14th Amendment binds the states. Here we consider procedural due process, substantive due process, and in particular, Fifth Amendment takings cases. And as you may recall, this is where constitutional law and the law of real property cross over. Finally, we consider equal protection, and in particular the Equal Protection Clause of the 14th Amendment. Here the method of analysis is simple and will be replicated more than once in our work together. First, we have to determine the standard that we will apply to reviewing the challenged action. And these can include strict scrutiny, intermediate scrutiny, and the rational basis test. Again, we need to be aware of how these principles are applied. It's far more important to be able to do the analysis with skill and precision than it is to be able to recite a masterful boilerplate definition. Once we determine what standard applies, then we evaluate the action taken by government according to the applicable standard. The bottom line to any con law essay question is the conclusion. We have to provide a concise answer to the question.